No.
Y'all want to make any other comment on this? Of course, I have to commit individual voir dire on the media. Any other comment from the state on whether to allow individual voir dire on the death penalty issue? And, well, let me hear that, and I'll hear from the defense, and then one other question.
Yeah, I mean, I'm not going to bore the court. I've made my point on that. I mean, I kind of got a standing objection on that. It's not an objection, it's a suggestion, I guess. But
I understand.
I stand by my original explanation that I just think it's very important that we get the things that are reserved and that they're open and honest. I don't think we're going to accomplish that by having a group of liars, and that the death penalty opinions are huge in this thing. So I'd ask that you continue on with the individual.
All right, now which do y'all want to do first? Let's see. All right, well, I'll tell you what, let me,
Your Honor, you want the other no-shows?
Get a minute. I'm going to have the state do an order to show cause on these folks that didn't show up. I don't have time to do it now, of course.
do we know what efforts, I mean, it is somewhat confusing, and just do we know what efforts the jury clerk has made to find out where these people are? Are we making phone calls or?
That's them right there.
They haven't been done yet. We're just found out about it.
Yeah, I mean, you know, I just would like to, I mean, I'll do whatever the court says.
Well, I'm not asking you to do it now, but I'm not going to just not do anything with these folks that don't show up. I'm just not. We got enough of that going on in regular cases. I'm not going to stand for that in this case. Did you talk about Mr. Beer? What was?
A message was left for him.
Never heard back from him?
As far as I know, that's the only one we've called. So Judge, would you be asking the jury clerk to call those folks that are not here today and kind of have a standing order for any that don't show up in tomorrow's group as well, to call them and remind them of their time that they're supposed to appear?
I thought I made all that clear, but...
Well, I mean, I would think so. I know some of those people were calling in, but today's group were call-in, so I suppose they could have confused themselves on the call-in, right? So they called in last night to know to be here at 1:30 today?
Well, everybody else got the message, but not the six that didn't show up, so...
I agree.
I just suspect, although I don't know for sure, that they didn't show up.
Well, Mr. Eisenhower and I leave here all the time. We don't know when we're supposed to come back, so I can see it happening.
Well, if that's the case, then they're not paying attention.
Yeah.
No, I understood. My point was more about taking some action to track them down so we know if they're coming or, you know, if they
You want to take that action, or you want to pawn it off on him?
Well, I don't think the court wants me calling jurors, so.
I don't have time to deal with it right now, thank you. I'll consider it. Just tell me, I'm not going to, folks that don't show up and don't have good reason, there's going to be some consequences. Okay, On the continuing the voir dire, I'll of course permit y'all to do individual voir dire on the media exposure, as I think that's necessary. On the death penalty portion of it, I'm going to exercise my discretion and rely on the following authority, if you'll bear with me. Boggs versus State, 667 Southern 2nd, 765 out of the Supreme Court. Johnson versus State, 608 Southern 2nd, 1992 decision out of the Supreme Court. Randolph versus State, 562 Southern 2nd, 331, Florida Supreme Court. Stone versus State, 378 Southern 2nd, 765, also out of the Supreme Court. Davis versus State, 461 Southern 2nd, 67. Pender versus State, 530 Southern 2nd, 391, First District decision. Wilding, 427 Southern 2nd, 1069. Knight versus State, 866 Southern 2nd, 1195 out of the Florida Supreme Court. I think there was another case Mr. Bagadol made reference to. I don't recall the name.
San Martin, 717 Southern 2nd, 462 out of the Florida Supreme Court.
I'll exercise my discretion. I'll permit y'all to do voir dire to the entire panel if you wish. If it comes to my attention we need to do individual voir dire on death penalty issues, I'll consider doing that. These cases I'm familiar with that I made reference to, this process was done and they were affirmed on appeal, to my knowledge. This process was affirmed on appeal. So do y'all want to do the individual voir dire first, or do you want to do the mass death penalty inquiry first?
Judge, I just want to make sure that my objection to doing group on death penalty is preserved.
It is preserved, I understand, and I understand the state's request.
And when you talk about the doing individual on the media now and going forward with the group, are you saying the group in reference to general questions for jury selection, or are we going to just do group for the death penalty?
Definitely. We'll do a general thing when we winnow down the pool to the final one.
I still suggest that we do the individual on the media before we go to death penalty.
Yeah, no, and I agree with that, and I also agree, as I have from day one, that A's and E's, if that's, I hear you saying that if it's a specific individual juror brought to the attention to address that, A's and E's, I got no objection with it. That seems to be a good use of our time. I have no intention of asking any questions. You're going to do your spiel and read the death penalty thing, and then we'll go back to media. And if there's an A and they want to talk to them, I have no objection to that.
Okay. All right. Well, let's bring them in. I'll read them the death penalty instruction, then we'll send them into the courtroom next door and start individual. Okay? Okay. So I'll go off the record, step off, bring them in, let me know when they're ready.
Paul, stand, please. Circuit Court will be in a short recess.
How many seats do you have next door?
How many seats? With the front, if you put the seats back in, 50. If you put if you put them black chairs back in front of the...
They're all still there.
Okay, then you'll have 50.
Specifically, so we're not going to agree on it. I'm not going to...
Okay, here we go. Page. Reach down here, please. Kenneth. All right. Carol. Orlando, you're going to leave two seats open next to you. Officer James. Harrison. Joseph, you're going to leave a seat open between. And Edward. All right. Alice. You're going to leave one seat open. Jorge. Teresa.
I'm Teresa.
Great. Lucie. Bruce. Catherine. Robert. Gail. Constant. And Lewis. Carl. Excuse me. Third seat. Robert. Nicholas. David. Melsai. James. Robert. Michael. Sarah. Carol. Kimberly. All the way down, please. afternoon. Terry. Gladys, you're going to leave one seat open. Robert, Carolyn, Maureen, Jennifer, William, you're going to leave one seat open. And we got Marisol, and we have John. Down at the end, one seat open, Scott, Robin. Stephen, you're going to be on the left side of this divider right here, correct? Leave one seat open, Michael, Christopher, and then James. All stand, please. Here, the Circuit Court of the 19th Judicial Circuit of Florida for St. Lucie County is now in session. Honorable Judge Dan Vaughn presiding. You may be seated.
Thank you all very much. Welcome back, everybody. Thank you all very much for your patience. Thank you for your patience. Thank you for your patience. Thank you for your patience. In just a minute, I'm going to read to you all instruction you'll receive potentially a little bit later on if you're selected to sit on the jury in this case. By me reading this to you, it's a little bit lengthy, but by me reading it to you, I think it'll expedite this process significantly for you. And I want to read it to you in its entirety in context. So when I read it to you, if you'll please listen carefully to it. We're going to be referring to it when we ask you some questions. But I think if I go ahead and read it to you now, it'll save us a significant amount of time a little bit later on.
Your Honor, may we approach?
Yes. I know the noise is annoying. All right, let me switch gears here just a little bit and orient you just a little bit. Folks, I want to welcome y'all to jury service. I know this is interfering with y'all's time and schedule and work and all that. I appreciate that. We are doing our best, and I'm doing my very best to make sure your stay here is as short as we possibly can make it, make it as comfortable as we can, and keep as informed as we possibly can as to what's taking place. I've got to respectfully beg you to please be patient with us while we go through this process. I won't keep y'all here any more than I absolutely have to. I promise. I know that y'all have obligations and lives and children need to be taken care of outside of being called in for this process. So we'll do our best, and I'll do my best to make sure your time here is used as efficiently as we possibly can make it, I assure you. I recognize that none of you probably want to be here. I recognize that probably none of you want to be here. I recognize that probably none of you want to be here and hope that somebody else will do it. But being called in for jury service, especially in this case, is an important duty that citizens serve in this country. Perhaps next to serving in the military is the most important duty that a citizen can serve in this country. And folks, somebody's got to do it. Somebody has to do it. Somebody's got to do it. Okay, so y'all have been selected to at least go through the process, and we'll do our best to make sure your stay here is as short as we can make it and make it as comfortable as we can. Y'all have been assigned to your little seats where you find yourselves are now. If you'll just make sure if you come in and out of the courtroom as a group, if you'll just sit in those same seats you find yourselves in now, it'll help things go along a little bit quicker and smoother. I have everybody's name here on a seating chart with a big cheat sheet with your name on it. I'll do my best to pronounce your name properly. If I don't get your name right, please tell me. I'll try my best to correct it and pronounce it properly. Most of y'all's names don't look too bad on here. There's going to be 2 or 3 of you I'm going to have trouble with. You know who you are. So if I mispronounce your name, please tell me. You've had your name mispronounced all your life. Probably. It's not going to get any better with me. So I'll do my best to pronounce it properly. And I will introduce you to the people seated here in front of you in just a few minutes once we get to that point. I promise, in just a minute or two. We're going to speak to you all here shortly as a group, and then have y'all come in probably individually on 1 or 2 quick matters each. I will take up any requests at the appropriate time to be excused from service on this jury. I promise I'll do that. I'll take up any requests to be excused from service on this jury at the appropriate time. In fact, when I send y'all over here next door, if there's any of you all that being here the next day or so is going to be a hardship on you, I'll have you put it in writing, and I'll consider that request before you leave today, I hope. Now's not the time to do it, but we'll get there. Now, this portion of the trial is known as the voir dire examination. Voir dire, 2 words from the old French language, which came to the English language back to the Battle of Hastings during the Norman Conquest. So you can see it's been with us for quite some time now, about 1,000 years. Voir meant to see and dire meant to hear, and the idea of this question process y'all are about to undergo is for the purpose of determining if your decision in this case would, voir meant to hear and dire meant to see, and that's not right either. Voir meant to see and dire meant to hear, and the idea of this question process is to give both sides in the criminal proceeding, the state of prosecution and the defense, an opportunity to see and hear the prospective jurors, in this case, which of course are you all. I will remind each of you, previously been sworn to answer questions truthfully. You're bound by that oath during this portion of the trial. You're going to be asked questions here shortly by myself, as well as the attorneys, in an effort to try and seat as fair and impartial jury as is possible in this case. Please understand the questions that we ask you are not for the purpose of unnecessarily prying into your personal affairs, or trying to be nosy or put you on the spot, but are solely for the purpose of trying to obtain as fair and impartial a jury as is possible in this particular case. I think you'll see from the questions we ask you, this questioning process y'all are about to undergo is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience which you or members of your family may have undergone, or by some special knowledge which you might have concerning the subject matter which is to be tried. The purpose of this questioning process is to try and obtain jurors who will fairly and impartially try the issues of this case solely upon the evidence presented here in this courtroom without being influenced by the outside factors. Now, if you feel or the court feels you could not fairly and impartially try this particular case, you could be excused from service on the jury for cause. It's called a cause excusal. Additionally, please understand that both sides in the criminal proceeding, the state of prosecution and the defense, have a certain number of what are called peremptory challenges or peremptory excusals, which means that either side can excuse a certain number of jurors without giving a reason for excusing those jurors. If you're not selected to sit on the jury in this case, please don't be offended or feel your judgment, your integrity, or your honesty is being questioned in any way. I assure you it is not. You all have been selected at random to come down for jury service and selected at random to sit in the seats that you find yourselves in now. And really, it's a luck of the draw where you happen to be seated if you're asked to serve. So we're not going to need all the folks we've summoned in to go through the process to sit on the jury. So obviously not everybody's going to get selected. So if you're not selected, please don't be offended or feel your judgment's being questioned. I assure you it's not. A couple other things. You'll notice when you, just a minute ago, let me back up just a little bit. You'll see a blue light here, this little fellow, blue light man here in front of me. That's a recording system that makes sure everything gets recorded properly. When the light's on like this in a constant fashion, I'm operating the system up here with some buttons here. That means the system is on, everything is being recorded properly. You'll see some microphones hanging over y'all's heads there. They're there to amplify y'all's voice and pick up your voice on the record. We're required under Florida law to make a record in each criminal case, and that's what the recording system is doing. You'll notice there's a camera up here behind my head. There's a nice lady in the back room monitoring the system to make sure everyone's voice gets recorded on the recording system. There's a nice lady over here on my left and y'all's right, the court reporter. She's taking it down stenographically also, everything that's being said. So if you'll just please make sure you speak up, especially as you get further back in the back there. If y'all just make sure you speak up loud and clear where we're able to hear you, get your voice recorded on the recording system, and this nice lady can take down what's said stenographically. If you speak up, things will go along a lot quicker and you'll get out of here that much quicker. If you speak up, this will get over quicker. If you speak up, this will get over quicker. If you don't speak up, you'll be down here longer. So just make sure you speak up. It'll help things go along a lot quicker and smoother for all of us. Now, in just a minute or two, I'm going to read to you all the pertinent portion of the indictment or charging document in this case that sets out the allegations in this case. When I'm done doing that, I'm going to ask you all, is there anything because of the nature of the allegations themselves that would cause any of you all to feel you'd be unable to be fair and impartial in this case simply because of the allegations themselves? I'll ask you, do you know anything about this case, either your own personal knowledge, by discussion with anyone else, or by reading or hearing about any of it in the news media? And then I'll introduce you to the people seated here in front of you. I haven't forgotten them, I'm not ignoring them. I'll introduce you to these folks here in just a few minutes. And I'll ask you if you're related to them by blood or marriage or have any business or social relationship with them. Now, the indictment is the charging document in this case. It informs or advises someone of what they've been formally accused of. It's not any proof of guilt. You shouldn't infer any guilt from it or assign any guilt to it. It's simply the document that's filed in the court file that sets out the allegations in this case. I'm going to read to you all the pertinent portion of that. It contains some legalese or legal language. When I'm done reading the legal language to you, I'll translate the allegations into plain English so you understand what the nature of the charges are in the indictment. And then I'll ask you all those questions I talked about. So if you'll please listen carefully and give me your attention. The indictment or charging document in this case alleges 4 counts or 4 charges. The first alleges on or about February 28th of 2013 here in St. Lucie County, Florida, that Eriese Tisdale did unlawfully with a premeditated design to effect the death of any human being, kill and murder Gary Morales, a human being, knowing Gary Morales was a law enforcement officer while Gary Morales was engaged in the lawful performance of his legal duties as a deputy sheriff with the St. Lucie County Sheriff's Office. And during the commission of the murder, the defendant did carry, display, use, threaten to use, attempt to use, or actually possessed a firearm, and did discharge that firearm, resulting in the death of Gary Morales in violation of Florida statute. The second count or charge alleges also on or about February 28th of 2013 here in St. Lucie County, Florida, that Mr. Tisdale did intentionally and unlawfully threaten by word or act to do violence to the person of Clarence Bennett, having the apparent ability to do so, and did an act which created a well-founded fear in the mind of Clarence Bennett that such violence was about to take place, and in the process thereof used a deadly weapon, to wit, or specifically a firearm. And at the time of the assault, Clarence Bennett was a law enforcement officer who was engaged in the lawful performance of a legal duty. And the defendant knew Clarence Bennett was a law enforcement officer and in the commission of the offense, the defendant carried, displayed, used, threatened to use, or attempted to use, or actually possessed a firearm in violation of Florida statute. The third count or charge alleges also on or about February 28th of 2013 here in St. Lucie County, Florida, that Mr. Tisdale did unlawfully own or have in his care, custody, possession, or control a firearm or ammunition after being convicted of a felony in the courts of this state, or of a crime against the United States, which is designated as a felony, or of an offense in any other state, territory, or country punishable by imprisonment for a term exceeding 1 year in violation of Florida statute. And finally, the fourth count or charge alleges also on or about February 28, 2013, here in St. Lucie County, Florida, that Mr. Tisdale did willfully flee or attempt to elude a law enforcement officer in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle with siren and lights activated in violation of Florida statute. Now, see, I told you it contained a lot of legalese or legal language. What it boils down to in plain English are: the first count or charge alleges first-degree murder of a law enforcement officer with a firearm. The second alleges aggravated assault on a law enforcement officer with a firearm. The third alleges possession of firearm or ammunition by a convicted felon. And the fourth alleges fleeing or eluding a police officer with lights and siren. Now that you've heard the allegations in this case, that's all they are at this point, are allegations. Is there anything because of those charges that would cause any of you all to be prejudiced or biased in this particular type of case, where you prefer not to scissor in this case because of a prejudice or bias? By that I mean, now that you know what the allegations are in this case, does that cause anyone to feel they would be unable to be fair and impartial in this case if they were asked to serve as a juror because of those charges? Does that apply to anyone? If it does, if you'll just please raise your hand for me. Okay, I see one way in the back there. Is it Mr. Hart? Okay. Mr. Hart, don't let me put words in your mouth, please. I don't want to do that. But do you feel because of the nature of the allegations themselves, you would have difficulty being fair and impartial if you were asked to serve? Speak up just a little bit.
Yes.
There we go. Okay, did I miss anybody other than Mr. Hart? Is it Ms. Alcias?
Yes.
Ms. Alcias, don't let me put words in your mouth either, ma'am, please. I don't want to do that. But do you feel because of the nature of the allegations themselves, you would have difficulty being fair and impartial if you were asked to serve?
Yes.
Did I miss anybody? I'll make sure I get everybody, I promise. Is it Ms. Bold?
Yes.
Is that pronounced properly?
Yes.
Ms. Bold, don't let me put words in your mouth. Do you feel because of the nature of the allegations themselves, you would have difficulty being fair and impartial if you were asked to serve?
Yes.
Okay. I saw a hand in the back, I thought. Is it Mr. Russo?
Yes.
Mr. Russo, do you feel the same way, that because of the nature of the allegations themselves, you would have difficulty being fair and impartial if you were asked to serve?
Yes.
Did I miss anybody else?
Question.
Yes, sir. Mr.
Warner,
When?
does that include if I read it?
We're going to get to that in just a minute.
Oh, okay.
We're going to get to that in just a minute. I promise. Okay. All right. Did I miss anybody else? It's a good question. We're going to get to it in just a minute. All right. Do any of you all know anything about this case other than what you put on your questionnaires? Other than that, do any of you all know anything about this case, either through your own personal knowledge, by discussion with anyone else, or by reading or hearing about any of it in the news media? Now, if I ask you a question, I don't want you to tell me what you've heard, just if you've heard something. So please don't tell me anything that you may have heard, just if you've read or heard something or know something about the case prior to coming into court today. All right. You'll raise your hand. Okay. Mr. Weiner, you may have read something. Yes?
Yes.
Okay. I don't want you to tell me what it is, but just that you have. Ms. Bowl, you read or heard about something before coming to court? Yes?
Yes.
All right. Anything else on the front row? Mr. Lozano?
Yes, does that include when it happened or this past week?
Both.
Okay, yes, when it happened.
And again, don't tell me what you may have heard, just that you've heard something. Is it Mr. Barnes?
Yes.
Mr. Barnes, you may have heard something about the case prior to coming into court.
Yes, sir.
Let me go down to his left. So Mr. Bowden,
Yes, sir.
you may have heard something before coming to court today about it.
Yes.
Mr. Galarza, you may have heard something about it.
Yes.
Did I pronounce your name properly?
Yes, sir.
And Ms. Estrella?
Yes.
Okay, you may have heard or read something about the case before coming into court.
Yes.
Let me skip anybody. Mr. Barry, is that your hand raised there?
Yes, sir.
You may have read or heard something about the case before you came into court today.
Yes.
And Mr. Minerva, next to you?
Yes.
Mr. Barry's left? You may have heard or read something about it, sir?
Yes, Your Honor.
Mr. Wilson, you may have read or heard something about the case before coming into court?
Yes, sir.
Is it Ms. Riley Hazel? Is that pronounced properly? Okay. You may have read or heard something about the case, ma'am? Yes?
Yes.
Okay. Thank you. Is it Raubert? Raubert? Okay. You may have read or heard something about it before coming to court? Mr. Tavito, you're in the same position, you may have read or heard something? And Mr. Stanley, is it?
Yes.
You may have read or heard something about it before coming to court today?
Yes.
Mr. Russo, you may have read or heard something about it before coming to court today?
Yeah.
Ms. Calindo, is that pronounced properly?
Yes.
Okay, you may have read or heard something about it before coming to court?
Yes.
Mr. Bethel, you're in the same situation, you may have read or heard something about it?
Yes, sir.
Is it Ms. Levine? Levine? I'm going to spell it phonetically, so I don't do it. Ms. Levine, you may have read or heard something about the case before coming to court today? Okay, I'm sorry, I may have skipped one. Mr. Polycarp, did I skip you? I'm sorry. You may have read or heard something about the case?
Yes.
Okay, I'm sorry, I didn't mean to skip you. Is it Ms. Sennett?
Yes.
Ms. Sennett, you may have read or heard something about the case?
Yes.
Okay, going down that row to her left. Is it Ms. Cameron Coster? Ms. Dick?
Yes.
Okay, sorry, I'm all the way back. You may have read or heard something about the case before coming to court?
Yes, sir.
Okay. And also, Mr. Hart, way in the back there, you may have read or heard something about it? Did I miss anybody? Okay, I'm sorry. Ms. Zimmerman, you may have read or heard something about it?
Yes.
Okay, didn't mean to skip over you. Anybody else? Did I skip over? Mr. Tate, did you say, do you have your hand raised?
Yeah.
Okay. You may have read or heard something about the case?
Yeah.
Didn't mean to skip it. Anybody else I missed? I don't want to miss anybody. Mr. Wooden?
Yeah, does that mean, just like you heard, it's possible to delay any information you're asking if when you were heard?
Yes.
Okay.
Okay, Ms. Zimmerman?
What if it's only on one count?
On anything?
Doesn't matter?
Doesn't matter.
Okay, sorry.
And Ms. Lowe, way in the back there. Okay, did I miss anybody? Okay. Now let me introduce to you the people that will be associated with this trial, the folks that are seated here in front of you. I'm going to ask you shortly if you're related to them by blood or marriage or have any business or social relationship with them shortly. I don't think you're married or related to them by blood, but you may be, so I just want to make sure. So if you'll bear with me. Mr. Tisdale is seated here on my left, and y'all's right, kind of circle, staying there in the middle for you. That's fine, thank you. He's represented by I'll go from my left to right. Y'all's right to left. Ms. Celadonio.
Good afternoon.
She's standing for you now. Mr. Glenn will stand up for you now.
Good afternoon.
Mr. Manship is the next fellow to y'all's left.
Hi, good afternoon.
Ms. Miranda is seated back here closer to me.
Good afternoon.
Ms. Miranda, if you introduce these two nice ladies to your left.
Yes, Your Honor. And also part of our defense team is Ms. Allison Mastis and Ms. Amy Perrin.
Thank you, ladies. Y'all have a seat. The prosecution is represented by Mr. Backadall. He'll stand up for you now.
Good afternoon, ladies and gentlemen.
And on y'all's far left, Mr. Eisenhower. They'll be representing the state in this case.
Good afternoon.
Do any of you all know any of these people? Are you related to them by blood or marriage? Or have any business or social relationship with them that you know of? Going to get married to them in the next few days or divorced? Okay, just check. Nobody knows any of these people? Not related to them? It's also very important, as I advised y'all, I think, when I saw y'all last time, please, until you're released from jury service on this case, do not read or listen to any media accounts of this case. Do not talk to anyone about this case, even your own fellow potential jurors. Do not allow anyone to approach you to discuss this case. And please don't read or listen or hear any media accounts about this case until after your deliberations are either finished if you are selected or until I discharge you from jury service. It's very important that y'all follow that instruction until you're discharged from jury service. Now, I can't emphasize to you enough, and I think it's probably apparent to you by now, the seriousness of these proceedings. I can't impress upon you anymore the seriousness of these proceedings. I appreciate y'all have obligations and things you need to do. Believe me, I appreciate that. And I will do my very, very best to accommodate you all. I promise. But bear with us while we go through this process. I'll do my best to accommodate y'all. But you've got to appear here when I ask you to. And if there's any hardships or anything like that, if you'll just please put it in writing and give it to one of the officers, I'll try and address it as quickly as I can. But I want to caution you, somebody's got to do this, and y'all at least have to go through the process. So if you'll just bear with us a little while, we'll get through it as quickly as we can. I won't keep you here any more than I absolutely have to. But if you'll be patient with us, it is an important process, and I won't impose on you any more than I have to. I promise. Okay? Okay. Let me have y'all step over here to this room right next door. We're going to start with some of you all. I'll let you know when it took. We won't be here any later than 5, probably. But we're going to at least get started with some of you all, and then when we're done, I'll give you some other instructions. Now, if there's an issue about serving the next day or so, please put it in writing. They'll bring it into my attention. I'll try to address it as quickly as I can. Okay? Okay. Thank you all very much. Let me just have you step right over here. These folks won't help
Folks,
me.
if you want to just go in your row order, and she'll show you where to sit. It's the first row to go first. And just kind of go in order. That way you stay in the same order. She'll show you where to go right across the hall. And then you can follow them behind.
Your Honor, before we get started, can I just address one of the jurors?
Yes.
Judge, Ms. Maureen did not proceed in seat number 42. Is my son's teacher. I may have had unintended contact with her, Your Honor. I didn't realize she was on our jury panel. I always thought her name was Mary, not Maureen, so I didn't put the two together.
Okay.
I just wanted to disclose that to the court at this
Okay,
time.
thank you. Well, I don't think she indicates she knew.
Right, it's the heritage. It's for non-civilian clergy.
Well, you can ask her, the state can ask her if they want. Okay, you
Yes,
want to have
sir.
Mr. Roderick? I'm sorry, was he one of the ones that indicated on the questionnaire that he knew something? Because I don't think he raised his hand a minute ago, so.
Who are we talking about?
Mr. Roderick, number one?
No, he did not.
He didn't, Judge. I was just going through the questionnaires to see who we had in here that didn't have any media exposure and was a C answer on the death penalty. And we were going to suggest that we just give those people cards. And
Well, if y'all want to agree on it, that's okay.
Cool.
So- Okay, we can do that in a minute, but
Yes, sir.
who, I'm asking, which side, who do y'all want to call in first on the media? Because I don't have access to all the questionnaires. All I know is the ones that just raise their hands.
the juror B14 in seat 2, Lozano, raised his hand and had it on his questionnaire about media.
Associate, the state doesn't want to talk with Mr. Roderick about media.
No, sir, he didn't mention on his questionnaire or raise his hand to that.
State or defense want to question Mr. Roderick about his media exposure.
Jane, that's your question.
Yeah, no, sir.
We have Mr.
No.
Lozano.
Can we give Mr. Roderick a red card and let him go then? To your point of it.
Yeah, I can. When do you want to have him come back?
That's a good question.
Are they going to call in Thursday night?
Yeah.
Have him call Thursday.
Might as well call with everybody else.
I'm sorry, the defense have him call back Thursday night?
I'm just having a difficulty understanding, we're sending everybody away except for media, and then we're having them all come back for group questioning now on the death penalty,
Right.
right?
That's right.
Okay. I thought maybe I heard somebody suggesting we don't bring some of the C people back for group questioning.
No.
Okay.
When we say group question, we're talking about the final board hour, when we get up and we do our thing.
I'm
Well-
talking about what he's having us do with the death penalty questions now.
I assumed that that was going to happen when we got our combined
We
group.
can do it then? But y'all want to do let's worry about the media stuff first.
Yeah,
We'll figure that out later. Okay.
Do you want me to bring them on?
Yeah, bring him in real quick. This is going to be a little more smooth. And you can bring Mr. Lozano in too if you wish.
Go like one at a time.
You can bring them both in because I'm going to let Mr. Roderick go.
Then come into the seat, we're just going to put them right there, sir.
Mr. Lozano's going to sit right there.
Right in the front row, and then...
Sir, up here, please. Just take a seat there 1 second.
Mr. Lozano, thanks for bearing with us. You're not in trouble or anything. You have anything wrong. I'm going to let him talk to you.
This is Mr. Rollins.
Well done.
Mr. Lozano.
Right here.
I need him there. Yes, sir.
Just reverse.
Okay.
What do you want me to? Right by this.
I'm sorry, Mr. Lozano. You have a seat there. And you're Mr. Roderick.
Yes.
Is that pronounced properly?
Close enough.
Okay. I'm going to let you go for today. It's a long story, but I'll let you go because we're not going to get to you. I'm going to give you this card with a phone number on the back here. If you'll call this number after 5 p.m. tomorrow, there'll be some information about whether we need you back or not. You don't need to come tomorrow, but if you'll call this number tomorrow after 5 p.m. Understand?
Yes, sir.
Okay, thank you. You're free to go, sir. Okay, now I got Mr. Lozano, right? Okay, we'll make sure I got the right fellow. You're not in trouble, you have anything wrong, we'll let him talk to you outside the presence of the other folks. So if you can just make sure you speak up more so we can hear, and get you on the record, and just be as candid with us as you can, okay?
Okay.
Good afternoon, sir.
Good afternoon.
Again, we would like to reiterate on behalf of the state our thanks for your patience. You're brought in here this afternoon to talk about some of the questions, some of the answers you provided in your questionnaire, specifically as it relates to information you may have gathered or collected from outside the courtroom, okay? Your media exposure. So you said in your questionnaire and you raised your hand, and we appreciate that. I start off by telling you that maybe to you, somewhat to your surprise, the fact that you may think you know something about the case from an outside source doesn't necessarily preclude you from serving in jury duty. Even if you formed an opinion based upon what you read, saw, or heard outside, you're not necessarily excluded from jury duty. What we need to assess is, number one, what do you know? And as a result of that, how strongly held are your opinions or personal feelings about it? And ultimately, whether or not you can follow the law, okay? Mm-hmm. So that's kind of like the framework I'm going to work with you on for just a second. This is a court of law. So only the law rules in here. Not our personal feelings, not our bias, not our opinions. But the law. And what the judge will tell you the law is, number one, first and foremost, as the defendant sits here today, you must presume him to be innocent. Foundation of the American criminal justice system. You understand that?
Yes, sir.
Heard that before?
Yes, sir.
Okay. Number two, we said, on behalf of the state, that he committed a murder. And when your government accuses a fellow citizen of a crime, guess who's got to prove it? Me. Okay? And the way we do that is through offering witnesses testimony and evidence in court. You'll see the witness, they'll swear and take an oath, you'll assess their credibility, you'll look at their testimony in light of the other evidence in the case, and you'll ultimately come to a conclusion as to what happened. You with me?
Yes, sir.
What I can't rely upon in carrying my burden on behalf of the people is what you learn from outside in the media. You with me?
Mm-hmm.
Okay. So let's start off with, now that you understand your obligations, tell me in as much detail as you can remember what you read, saw, or heard about this case from outside sources.
When it did happen, when it was all over the news back in 2013, all I know is that the defendant ran from Sergeant Morales and in a vehicle which gave chase, and that he shot him. I'm not too sure of details because it's been, you know, a couple years since it did happen. But to the best of my knowledge, that's the main part of what I really remember.
Okay. All right, so with that in mind, at that time, did you form opinions regarding the defendant's guilt or innocence, or the person they called the defendant in that case, in the paper?
I can't be 100% sure.
Right.
Because I don't know all the evidence that was brought, that's brought into the case.
But can I interrupt you for a second?
Yes, sir.
Guess what you don't know? You don't know any of the evidence.
I don't know any of it.
Okay, that's right. So in terms of what you saw in the paper, though, did you form any opinions that are set in stone, that you are committed to, that you cannot set aside and fulfill your legal obligation in this case?
Nothing is set in stone,
Okay.
in my mind, because of apparently, it's all, I don't know how I can say it, charges that were brought against the defendant, but I'm not 100% sure if those charges are true and correct.
Right.
So therefore, I can't make a opinion based upon something that I don't know all the details about.
You're right. I mean, and I've asked, for I don't know how long we've been here, but a while. Many of your fellow jurors, do you believe everything you read in the paper? And I ask you, do you believe everything you read in the paper?
No, I do not.
Okay. So look, I don't mean to disparage the media, but the media will get a report or read a witness statement or something and then put their own spin on it or their own interpretation of it. That doesn't mean that's what the truth is. You with me?
I'm 100% with you.
Okay, so here's the question. Understanding that the defendant must be presumed innocent, okay? Can you promise us that you will set aside anything that you may have read, seen, or heard before coming in here and any opinions previously formed by you and give the defendant his constitutional right to the presumption of innocence?
Yes, sir.
Very good. Finally, can you assure us that you will hold us to our burden? That is, you will make sure that whatever opinion you arrive at, whatever verdict you arrive at in this case, is a result of what you see and hear in this courtroom and this courtroom alone?
Yes, sir.
Okay. So, I think that's all I need to talk to you about. Thank you.
Okay, you're welcome.
Mr. Vaughn.
How are you?
Good, thank you. How are you?
Good, thanks.
I'm just going to ask you some questions about your media and kind of what you've heard and what you think about things, okay?
Mm-hmm.
I know that you had indicated on your questionnaire that you had been exposed to some media, but you also raised your hand today, so I wasn't sure whether you were raising your hand about what was just inside of your questionnaire, or have you heard anything since you filled out the questionnaire about a week ago?
The only thing that I have heard was that and that was from the news, I didn't go into reading any of it, was that the jury selection was being, not postponed, but it's delayed.
Okay.
That's the title that I read, but I didn't go into it.
Okay, where was the like what type of media?
On Channel 5's website.
On Channel 5's website. Okay. So did it have content to the story, or did it say why it was being delayed?
No. It just showed a picture of the defendant with the title, and that was it.
Okay. So you followed the judge's instruction. You didn't click on the link. You didn't read it.
Yes, sir. That's correct.
Good. Any other media or anything else you've been exposed to since last week when you filled out the questionnaire?
No. Mm-hmm.
Okay, good. You haven't had to walk away from anybody talking about anything?
No.
All right, so I want to take you back to 2013. That's when you said that you originally heard something about the case, right? Okay.
Originally?
Yes. So how did you first wind up getting exposed to any type of media for this?
Through the TV, from the news, just watching the regular news.
And what do you remember hearing on the news?
All I remember is what I told the state was that the defendant supposedly ran from the sheriff deputy and that he shot him. Why? I have no idea. That's the only thing I can truly remember.
So after you saw that on the TV news, I'm guessing that wasn't the first and only time that you saw anything, right?
Could you repeat that question?
I'm guessing that the one news clip that you saw wasn't the only time that you ever saw anything about
No,
this, right?
no.
Of course not. It was constantly popping up on the evening news and the morning news, right?
As best as I can remember, yes.
And I'm assuming that you also wound up going online, or how do you get your news? Do you get newspapers delivered to your house?
No.
Okay. Do you have subscriptions to online newspapers, like to where you pay money?
No, I don't pay any money for any news.
All right, so just the free local news. Right?
Yeah, the only news I either watch on TV, but that's rare whenever I do watch it, but it's primarily just going online and reading it.
Okay. Smartphone? Access
Smartphone.
there too?
Yes.
Okay, so after you heard about it on the news, did you then look for some, and it's okay, did you then look for some written stuff about this to get more details?
Best as I can remember, back in 2013, probably not. The only time I truly remember ever hearing anything was on the TV at my parents' home. Other than that, I never searched out the case to read into detail or anything of that nature.
Okay. So have you read any written accounts?
No.
So what exposure on the internet have you had to this case, other than what you already told me about how you saw something on within this past week and you didn't click on it?
That was probably about it. Until when we were told that this was the case that we were being summoned to, I haven't read anything about this since it probably happened. I couldn't even tell you.
So did you, and I think I'm probably misheard you, but did you only just watch the one television broadcast about it, and then that was it, back in 2013?
I don't remember how many times I saw it on TV. That I don't remember. I do remember watching it. How many times, though, I don't remember.
It was more than once, right?
It could have been, yes.
Would you say it was more than a dozen times?
No.
All right. Who is it that you work for?
I work for the Palm Beach County Sheriff's Office.
And in what capacity?
Right now, I'm still a civilian, obviously. I work in intake and release in the jail, in inmate management.
And how long have you been working for the Palm Beach County Sheriff's Office?
I just hit a year, September 12th.
And what law enforcement did you have prior, what law enforcement experience or training or desire to go into the training did you have prior to starting in September 2013?